Good morning.
Welcome to the First District Court of Appeals. We have several cases on the docket this morning. Two will be argued. The first case that's going to be argued is State versus Deal. Ms. Larcade is here on behalf of Mr. Deal, and Mr. Cumming is here on behalf of the state of Ohio. Ms. Larcade, you will have 15 minutes this morning to argue. Would you like to reserve any time for rebuttal?
Yes, Your Honor, if I could reserve 2 minutes for rebuttal.
All right, I will keep your time, and whenever you're ready, you may begin.
Thank you, Your Honor. May it please the court. This is the second time this case is appearing before this court, and to get started, I will just give a brief recap of the procedural history. In 2017, Mr. Dial pled guilty to trafficking in marijuana, which is a deportable offense under federal immigration law, with no waiver or other immigration relief available. In 2018, Mr. Dial filed a motion to vacate his conviction and withdraw his guilty plea based on ineffective assistance of counsel as it related to advice on the immigration consequences of his plea. The trial court denied that motion without a hearing. Mr. Dial appealed. In 2019, this court reversed the trial court's denial, found ineffective assistance had been demonstrated, and remanded to the trial court for a hearing on the issue of prejudice. On July 20th of 2020, the trial court held the evidentiary hearing and again denied Mr. Dial's motion to vacate conviction and withdraw guilty plea, finding prejudice was not demonstrated. Mr. Dial timely appealed, which brings us to today's argument. The only issue now before this court is whether Mr. Dial suffered prejudice as a result of his trial counsel's ineffective assistance. And
I hate to stop you right now, but and I may have read over this. I have a question about the degree of offense to which Mr. Dial pled, and what was the degree of the offense in the original indictment. And I may have read over that, but can you tell me what that was?
Your Honor, I know that he pled guilty to the F5 trafficking charge. I don't have the original indictment in front of me, so I don't recall off the top of my head what the charges were in the original indictment. I apologize.
Okay, thank you. Thank you.
And so as to the issue of prejudice, I just want to point out two important points from this court's prior decision in this case that should inform this issue. First, again, this court held that it was clear from the record that Mr. Dial's trial counsel gave him the incorrect advice during the plea hearing, and that's in paragraph 27 of this court's decision. And second, the court found that Mr. Dial's attorney had a duty to determine whether he was or was not a U.S. citizen, and if he was not, to properly advise him of the immigration consequences of his guilty plea. That's in paragraph 28. And the reason I bring up that point is because this case is rather unique in that during the plea colloquy, Mr. Dial stated to the trial court that he was a U.S. citizen. And this is kind of that one fact that has been the focal point, at least for the trial court, on the issue of prejudice. The trial court initially held that Dial was not entitled to withdraw his guilty plea based on that statement, that if he stated to the court he was a U.S. citizen, he therefore waived any right to effective assistance of counsel on the issue of immigration consequences. So we'll come back to the trial court's discussion of that issue, but I want to get right to State v. Romero, which was decided just before this court first decided Dial's case. And the Supreme Court of Ohio held that in determining whether prejudice was demonstrated, the trial court must consider the totality of the circumstances, and the Supreme Court provided a non-exhaustive list of factors to consider. So I'll go through each of those four factors, the first being the reasonableness of going to trial or the consequences of going to trial. And it's clear that the trial court in this case weighed this factor very heavily. At the outset of the evidentiary hearing, the trial court read excerpts from the PSI that alluded to the strength of the evidence in the case. And therefore, the court felt that Mr. Dial could not demonstrate prejudice because of the strength of the evidence in the case. However, the trial court ignored the fact that there had been a motion to suppress filed based on an issue as to the admissibility of that evidence. As is often the case, after a motion to suppress was filed, a plea agreement was worked out and the motion to suppress was withdrawn. If Mr. DL was a US citizen, that would have been a good deal. However, he was not, and that's the problem in this case. So the trial court believed that the strength of the evidence precluded a finding of prejudice. However, there was that issue of the admissibility of that evidence. And regardless of whether that evidence ultimately would be admitted, the Supreme Court of the United States in J. Lee held that even if there's overwhelming evidence, if the issue of deportation is central to the decision-making, a Hail Mary at trial is reasonable for someone in that position, which brings us to the next Romero factor, which is the importance the defendant placed on avoiding deportation. At the evidentiary hearing in this case, DL's trial counsel testified that the issue of DL's citizenship and the potential deportation came up many times in their private discussion, thus signifying that they talked about it many times and it was an important factor, a central issue in Mr. DL's decision-making. Again, unfortunately in this case, trial counsel clearly did not resolve those issues effectively because there was still confusion at the time of the plea colloquy. Additionally, Mr. DL submitted a sworn affidavit and later testified to the fact that had he known he would be subject to mandatory deportation as a result of his guilty plea, he would not have entered that plea and instead taken his chances at a trial, Hail Mary or not. And perhaps his trial counsel could have negotiated a different plea that did not involve those stark consequences. Other factors corroborate this position, and that brings us to the third Romero factor, meaning connections to the United States. Mr. DL came to this country in 2004 when he was just 16 years old as a refugee asylee after his father fled persecution in Mauritania. He and his entire family have lived in the US ever since, and he has no family in his native country of Mauritania. So he has deep connections to the United States, and those also corroborate the fact that he wouldn't have pled guilty had he known he would be deported. Finally, the fourth Romero factor involves the judicial advisement of immigration consequences. This court has already held in this case that the trial court's advisement does not cure any deficient performance by counsel, citing to Romero. That's in paragraph 30 of this court's earlier decision in this case. Nevertheless, the trial court still relied on its advisement and questioning of Mr. DL during the plea colloquy to again deny his motion. In its second decision denying Mr. DL's motion, the trial court essentially found that its follow-up questioning sufficed to ensure the plea was made knowingly and intelligently, whether Mr. DL was a citizen or not, therefore precluding any demonstration of prejudice. The trial court asked this question multiple times in different ways. If for some reason you're not a US citizen, you could suffer those consequences. If you're a US citizen, it doesn't matter. And I would submit to the court that that provides no clarity to a defendant standing in front of a judge, entering a guilty plea, who doesn't understand whether he's a US citizen or not. If for some reason you're not a US citizen, you could suffer these really bad consequences. But if you are a US citizen, it doesn't matter. Again, the trial judge said, if for some reason you're not a US citizen, everything I've advised you regarding these immigration consequences applies. And my question to you is, do you wish to go forward with your guilty plea regardless of any immigration consequences, even if it means removal from the United States and you're never able to return? Those quotes are from the plea hearing transcript on pages 7 to 8.
Counsel, I just want to clarify, this court in the previous decision already found that that wasn't sufficient, correct?
That is correct.
Okay.
And then on remand, the trial judge held that Mr. DL couldn't demonstrate prejudice because the trial court asked him in these roundabout ways, you know, if you're a US citizen, this doesn't apply, but even if you aren't a US citizen, you could be subject to deportation. Knowing that, do you still want to enter your guilty plea? That was the reasoning of the trial court to find that there was no prejudice. And again, I would submit to this court that this court found that the advisement did not cure trial counsel's ineffective assistance, but the trial court's advisement and questioning also did not preclude a finding of prejudice. And I would submit to the court that the trial court's questioning on this issue is confusing and meaningless, for lack of a better word. Again, if there's a defendant standing in front of a judge who believes that he's a US citizen, his trial counsel has not corrected that belief, which again, this court held trial counsel had a duty to do. Immigration and consequences, therefore, he believes does not apply to him. What meaning does it have for the trial court to say, if for some reason you're not a US citizen, you could be ordered removed, you still want to plead guilty? It doesn't preclude a finding of prejudice because he said yes to that question under the belief that deportation would never apply to him. And during this questioning is when Mr. Dial demonstrates that confusion. He says things like, well, when I leave the country, I'm a US citizen. And the court continues this questioning over Mr. Dial's obvious confusion and over trial counsel's interjections to say, Judge, he's not a US citizen. Here's what I think, applies to him here. It seems the trial court and the defense counsel were okay with this plea, even though the defendant was still confused. And so on this record, again, the judge found that his questioning precludes a finding of prejudice, but there's no way that this plea was knowingly and voluntarily made when the defendant is obviously confused as to this very vital issue of whether or not he's a US citizen. And there's a difference between his opinion and his attorney's opinion.
And you have a little over a minute left if you want to reserve to.
Thank you, Your Honor. And so I'm kind of mixing the issues of a knowing and voluntary plea and the prejudice, but again, that's kind of where the trial court came down, is he asked these questions and Mr. Dial saying yes precludes a finding of prejudice. And I would submit to this court that it simply cannot be that questioning and Mr. Dial's responses would preclude a finding of prejudice. In conclusion, Mr. Dial demonstrated prejudice under the totality of the circumstances, specifically those 4 Romero factors. His incorrect statement that he was a US citizen, which was the result of trial counsel's ineffective assistance, cannot preclude a finding of prejudice, and neither can the trial court's advisement and equivocal questioning of Mr. Dial during the plea colloquy. Thank you.
Thank you. Mr. Cumming, you have 15 minutes.
Good morning, Your Honors. Thank you. Your Honors, this case is governed by the case law that we discussed, Romero. Recently, I think Bazo also reaffirmed the Romero standard. Basically, what these cases say is the fact that the defendant, after sentencing, is saying that he wouldn't have entered the plea if he'd known he was going to be deported is not good enough. You have to look beyond that post hoc assertion, and you have to look at contemporaneous evidence that he can point to that supports his claim that but for this error by his attorney, he wouldn't have pled. So that's why we had the hearing. This court ordered the hearing, and that was Mr. Dial's opportunity to point to contemporaneous evidence that this was a big deal to him. Deportation was a defining issue for him. It decided, it was determinative of his factoring in what to do or not. And he just didn't provide any, Your Honor. That's the bottom line. He provided no evidence at that hearing that this was an important issue to him.
Well, didn't he say he wouldn't have entered the plea if he knew he was going to automatically be deported? Isn't automatic deportation a significant penalty to somebody?
He did, Your Honor, he did say that, but all of these defendants in these cases say that. And the Supreme Court says, you know what, that's just not enough. We have an interest in our society in finality, especially in guilty plea cases. And
what evidence would suffice in your opinion?
Well, I look to the case law, and the case law, for instance, U.S. Supreme Court in the Lee case says that withdrawing pleas for these reasons is very unusual. It's an extraordinary remedy. And the only reason they granted it in Lee's case was because Lee presented overwhelming evidence that he was completely guided by the deportation issue in his case. He asked his attorney about it constantly. He bugged the attorney so much, the attorney was annoyed with him about talking about deportation consequences. His attorney testified on his behalf to the same effect, that Lee was worried about this. It was a big deal to him. And for that reason, in Lee, a very unusual case that Justice Roberts noted, they allowed him to withdraw the plea because there was so much of this contemporaneous evidence that to Lee, this was a big issue for him in deciding whether to plea. Dial is exactly the opposite. At the hearing below, he said he didn't even discuss the deportation consequences with his attorney.
Well, wasn't that because he thought he was a citizen?
That's what he's claiming, yes. But if this is such a big deal to him, I think most people could look at that and say it's reasonable that he would have talked to his attorney about it.
But his attorney had the duty to find out if he was a citizen.
Well, this court's already determined that the attorney violated that duty. So we're beyond the fact that his attorney was ineffective. That's established. But now it's the ball's in Dial's court to establish prejudice from that violation of duty. And that's where you look to the contemporaneous evidence, and that's where Dial falls short. James Bogan testified that he couldn't recall if this was important to Dial. He said, we talked about it. I don't recall if it was a big deal to Dial. Dial himself said, I didn't talk to my attorney about it. If you look at the actual plea transcript hearing, what I take away from that is there was confusion. I think my counsel is correct. There was some confusion at the plea hearing. He said, hey, when I go overseas, I show my passport and I think I'm a citizen. And Bogan was saying, well, I think even if you're removed from the country, it's going to be a discretionary thing. I guess my point here, Your Honors, is this. There was uncertainty at that plea hearing as to the status and whether or not he'd be automatically deported. That was clear on the record. And yet he blew past that. He was very dismissive of that. And even though Judge Kubicki 3 times said, hey, look, but I know what you think you're a citizen, but let's pretend you're not. Do you still want to do this? He did that 3 times. And each time, y'all blew past that and said, yes, yes, yes. So that's the type of evidence we have here. And we have nothing that he pointed to at the most recent evidentiary hearing that changes or adds to anything that he's already said in the affidavit that I wouldn't have pled had I known. But
Can we consider circumstantial information? For example,
sure.
He came to this country as a teenager. He was very young, in his young 20s when he was charged. His family came because of persecution. He doesn't have any family left in a country that presumably is still would persecute his family. Can we consider all that and whether there's prejudice?
Absolutely. In fact, the court, advises you to consider all of those factors. For instance, in the Lee case, that was a very important factor because I think Mr. Lee had started not 1 but 2 businesses in this country, and he was well, and he was engaged and invested in his success in the country. This factor was not well developed at the hearing below. There's not really much there. There was not meat put on the bone there on that factor. I think the most determinative issue here, or the most telling issue, is the plea transcript itself, Judge Kubicki's admonitions 3 times, which the defendant very confidently blew past. And the fact that he was told 3 times by the judge below that, forget what you think you know. What if you're going to be automatically deported? And each time he says, I want to do this. I want to do this. And I think this is the type of case that tells us one thing. It's not extraordinary. It's not the Lee case where somebody has clearly proven that this was the determinative issue for them in deciding to plead guilty. In this case, falls much more into the garden variety cases, which says that these post hoc assertions are just not sufficient to set aside a plea, especially when they're unsupported by any contemporaneous evidence that it was a big deal to him. And we have none here. His attorney said he doesn't even remember talking much about it with his client. It wasn't a big deal that he recalls. And the client himself said, I didn't even talk to Attorney Bogan about this. This is the type of evidence that came out at the hearing. This is not the kind of evidence that's going to support a finding that this was a determinative issue for this man. And I think when you combine that with the trial judge's over and aboard 3 times going above the standard advisement and really saying, look, you have to think this through. Do you assuming you're not a citizen, you could be out of here. Do you still want to do that? And he says, yes. Under these circumstances, I don't think this court can find an abuse of discretion by Judge Kubicki in finding that he just didn't meet the standard here. And I think that actually this is a good case that demonstrates the type of evidence that's just not going to get you a withdrawal of a plea.
Mr. Cummings, let me ask you a question. I'm sorry, I think I just spoke over somebody, but I don't have any quarrel with what the trial judge did in his advisement. But, you know, we read these cases, Lee and the Basso, they indicate that the judge's advisement is not a substitute for the advice of counsel. That's pursuant to Mr. Doyle's Sixth Amendment right. So I think, in my opinion, I think the judge did it right. Now, the question is, since it's not a substitute, how would you respond to that?
Well, you're right. That's exactly correct. It's not a substitute for the counsel's advice, and it doesn't cure the counsel's ineffectiveness. But the case law says it does go to the evaluation of prejudice. It goes to the second prong analysis. So it's important to understand at this stage in the proceedings, it's the defendant's burden to show that but for his counsel's failure, he wouldn't have pled guilty. So the burden is on him to show that this was a big deal to him. And he had to bring forth some evidence at this hearing to show that. And we didn't get any. We got...
Mr. Cummings, his attorney affirmatively gave him bad advice, which we've already found.
Right.
Don't you think we need to consider that as well?
Well, yeah, that's part of the two-prong analysis. Was the attorney ineffective, and was there prejudice? This court's already found that his attorney was ineffective. So all we're talking about now, though, is based on the record, did this violation of an essential duty cause prejudice here? And has DL demonstrated that?
But counsel, isn't the ineffective assistance in this case, doesn't that lead to a finding of prejudice? I mean, the fact that he had the duty and didn't tell him he was a citizen, he thought he was a citizen, and he said that it was not mandatory that he is deported. So that was ineffective, yes, but doesn't that reflect some prejudice there?
No, that's a separate inquiry. The cases say that the violation of a duty is one thing, and then the second part of it is, did that violation of a duty cause the defendant prejudice?
I understand that. My question wasn't whether it was two different factors. My question was, if putting yourself in the defendant's place, if somebody didn't tell you whether or not you were a citizen and you thought you were a citizen, and then your attorney said to you that deportation is not mandatory, and you made your decisions based on that, doesn't that show some prejudice?
Well, all of that, of course, factors into the analysis, but it's not a per se rule. And the courts have not established that rule. If they wanted to say every time you had a scenario like this, it's per se prejudice, the U.S. Supreme Court could have done so. The Ohio Supreme Court could have done so. That's not the analysis. You don't necessarily just presume prejudice because the counsel made this type of error.
But following up on Judge Bach's question and an earlier question she asked, isn't what removes this from the garden variety of case the fact he believed that he was a U.S. citizen? And normally we wouldn't have that factor. And isn't that what leads to, or could lead to, a conclusion of prejudice? He really believed he wasn't a citizen so that the deportation wouldn't apply.
Well, I don't think it's clear that he did say he thinks he was, but he also qualified that. He tried to explain at the hearing, well, you know, when I go overseas, I show my passport, and Mr. Bogan chimed in, well, I think it's discretionary, maybe. There was uncertainty that was replete in the record of uncertainty about this issue. He did say that he thought he was. You're right. He did say that, and that's why the trial judge picked up on this, and that's why Bogan picked up on this, and they pursued it with this man. And he said, even though that I might be wrong, I still want to do that. That's the takeaway from the transcript of the plea hearing.
But isn't that what removes it from being a garden variety? You referred to it as a garden variety case earlier. Isn't that the one factor that removes this from being ordinary and perhaps pushing it to extraordinary?
Well, I mean, that's for this court to determine. I don't think there's a case out there that says that if the person thinks he's a citizen, that removes it. You still employ the same analysis of prejudice at the end. It just becomes another factor among the totality for this court to consider. But yes, it should be considered. No, it's not automatic prejudice. And I don't think that uniquely takes this case out of the paradigm. You still have to apply the standard. You still have to put the burden on him to show that, but for this error, he would not have pled. And he has to come forward with that contemporaneous evidence at the hearing below. And he didn't. He actually presented just the opposite. He said, I didn't talk to my attorney about it. I think I was a citizen, but he could have said, I still wanted to ask my attorney and make sure. He didn't say that. He said, I didn't know. I just didn't even talk to him about it. Now, that I understand your point, Judge Myers, that could go both ways. He might think he's home free. I think when you read the transcript, though, the uncertainty is clear from that transcript that all the parties there were not clear about anything. And I think that if that was Lee at that hearing, he would have been saying, stop, wait. And that's what Lee did at his hearing. He said, wait a minute, I'm not sure I want to do this. And that's what put his case different. He was in real time expressing hesitancy to go forward. What makes Dial's case different here, Dial's case is, he was adamant. He waited. And he definitively and affirmatively said, I'll take the risk. I want to go forward with this plea. And even at that hearing, it was somewhat unsure what his status was. And Bogan was saying, Attorney Bogan was saying, you know, you might be automatic, but I think you're just discretionary. My point was, it was all part of the fabric of that hearing. This uncertainty was part of that. And he chose to go forward anyway, after being challenged 3 times by the trial judge. I think that's what takes this case out of, the garden variety case that says he's clearly prejudiced. He's clearly wasn't, based upon the hearing below. And he didn't present any evidence beyond his post hoc assertion that would show that he was prejudiced. And that's what all the courts have said isn't good enough. You need more than just saying, hey, look, if I really knew, I wouldn't have done this. They say that's not good enough. You need more than that to set aside a plea. And that's why that was done in Lee, because it was so unusual and so extraordinary based upon the evidence he was able to bring, that it was a contemporaneous concern for him at the time. This man here has not done that. And I think that's what makes this case different from Lee. And I think that's why it can be said the trial judge below abused its discretion here. I mean, this court would have to find that the trial judge was arbitrary and capricious in taking this man's word for it 3 times that he wanted to plead that day. And I think that's an awfully hard thing to do.
You have about a minute left.
I have nothing further, Your Honors, unless this court has. Oh, Judge Winkler, I did have an answer to your question about the original indictment. Count 1, he was indicted for trafficking in marijuana, an F5. Count 2 was possession of marijuana, which was an M4. And count 3 was possessing criminal tools, which was an F5.
He essentially is charged with dismissal of the criminal tools.
Yes.
Is that right? Okay. Thank you.
Thank you, Your Honors.
Thank you. Ms. Arcade, you have 2 minutes remaining.
Thank you, Your Honor. I would submit that the state is asking for the impossible. Contemporaneous evidence that deportation was a determinative issue when the defendant thought he was a U.S. citizen and his trial counsel failed in his duty to advise sufficiently that he indeed was not a U.S. citizen and that deportation would result as a result of his guilty plea. Now, I would challenge the state's assertion, because Mr. Bogan himself did testify that the issue came up a number of times, the possibility came up a number of times, and it was a concern that we brought up. That's on the transcript, page 47 of the evidentiary hearing. So there was evidence presented at the hearing that this was an issue that came up. But again, this case is extraordinary, and it is not the ordinary case, because we have this added layer of the defendant did not know that he was not a U.S. citizen. So he didn't suffer prejudice just because of his attorney's affirmative misadvice as to the immigration consequences. He suffered prejudice because his attorney never adequately explained to him that he was not a US citizen. Those consequences would apply to him. And that is a threshold issue in this case. So Mr. Dial has met his burden to demonstrate prejudice. If he believed he could be deported to a country he has not known since he was a child, as he swore in his affidavit and testified again at the evidentiary hearing, he would not have taken this plea. He would have gone to trial. Again, the facts are, as to prejudice, similar to Jay Lee in the ties to the United States. And the Supreme Court did say that an affidavit or testimony that they would not have pled guilty but for the incorrect advice may suffice. So in this case, Mr. Dial has presented sufficient evidence of prejudice, and he was prejudiced by his trial counsel's failure to advise that he was not a US citizen and affirmative misadvice if he were not a US citizen, the immigration consequences that would result from his guilty plea. And so he is entitled to withdraw his guilty plea, have his conviction vacated on those grounds. Thank you.
Thank you both very much for your arguments this morning. We will take this case under submission and give you a timely written opinion. Thank you.
Thank you.
Thank you.
Ms. Hayden, if you will bring our next case into the courtroom. Good morning. Our next case on the docket this morning is State versus Spivey. Ms. Peters is here on behalf of Ms. Spivey. Ms. Steer is here on behalf of the state of Ohio. Ms. Peters, you will have 15 minutes to argue this morning. Would you like to reserve any time in rebuttal?
Yes, Your Honor. I'll reserve 3 minutes, please.
All right. Whenever you're ready, you may begin.
Okay. As I did with my brief, Your Honors, I will refer to my client as Ms. Ball, because the record usually through the trial process referred to her as Ball, though we were told when we were doing the appeal her name was Spivey, so that's how the case caption got switched. May it please the court, Ms. Steer. In this case, there are 2 assignments of error, and the second assignment of error is an allied offenses in which the state has conceded the error. So unless there are any questions from the court, we'll just submit on the brief on that second assignment of error. Okay. With regard to the first assignment of error, my client, Ms. Ball, was charged and convicted of 2 counts of child endangerment. And this arose from the fact that she left her 6-year-old and 3-year-old grandchildren that she was custodian of at the time in the parking lot at Target in the vehicle. However, when you look at the facts in this case, you'll find that she did not actually create a substantial risk of health or safety to the children and therefore did not violate a duty of care or protection or support of these children. In order to be guilty, she had to be reckless and act with heedless indifference to the consequences or perversely disregard a known risk. And in this case, the state argues that the known risk was the exposure to the freezing weather. Now, what parent has not sent out their child to play in the winter time? So as long as they're—
Ms. Peters, go ahead, Judge Myers.
Sorry, Judge Bach. Ms. Peters, let me ask you this. Don't we have an added fact here? That added fact being she knowingly went back into the store and knowingly took the risk of shoplifting and getting caught and being detained. Isn't that reckless? Because what if somebody just put her in a back room until the officers arrived? She had no way of telling anybody that the children were out in the cold, or if they had detained her and it took a long time for them to get to the children. I mean, isn't that an additional factor that we should consider?
Your Honor, it may be an additional factor, but I would say in this case, she immediately told the Target personnel that her grandchildren were in the car and requested that to be able to go get them. So within 5 minutes of her being taken into the back room, she informed, as Mr. Roberts testified, he's the one who, she testified she told the woman immediately that her grandchildren were in the car. And Mr. Roberts testified that that he had placed the call to non-emergency based on the theft. And then when he got her back into the room and she said, my grandkids are out in the car, he then called a second time, this time with 911. The record reflects that call came within 5 minutes. So even then, the kids were not out of the car for more than 15 minutes.
But I guess my question was, isn't that just by, I won't say luck, but thank heavens that happened. Couldn't it have easily gone the other way? Because what we look to is whether or not there was a substantial risk of harm and whether or not she acted recklessly.
Well, in State versus Bush, Your Honor, this court said, when evaluating the recklessness, you do need to consider what steps or precautions the parent, or in this case, the guardian, took to negate the risk. So that risk that you're talking about, that the children would be in there an extended period of time, didn't exist because Ms. Ball immediately negated that risk by telling the target personnel and actually inquiring several times of the officer about the status and the welfare of her grandchildren. So it's not that she was disregarding a known risk. She was aware of it, and she was consciously and trying to prevent that risk or that exposure from happening. So she took the steps in this case, to prevent any extreme exposure or substantial time exposure to the elements. And in this case, the children were in a car, they were locked. If you compare this case to some of the other cases that have been out there for child endangerment, and yes, I realize that child endangerment convictions are highly fact specific, and a lot of times there aren't cases directly on point. However, this court in Martin, a mother went inside a store and was gone for over 20 to maybe at least a half hour to return an item, and her child woke up in the back seat and actually managed to put the car in gear, and the car rolled out into a lane of the lane. And in this
counsel, in that case, the child was 8, he was turning 9 the next day, and there weren't any weather issues like in this case. I don't necessarily see that as on point at all, really, because it wasn't foreseeable that he was going to put that in gear. In this case, it was 15 degrees out. And one thing I was confused about, there seemed to be some conflicting testimony about what the children were wearing. Was there any video that showed what they were wearing that the trial court saw?
Yes, Your Honor. Actually, there is video. The body worn cam video, Exhibit 3, I believe it is, because I think Exhibit 1 is.
Did the court view that entire video? I viewed it, but I didn't know if the court viewed the whole thing.
Well, it was admitted, so I would presume that the trial court, because it was admitted into evidence, that the trial court reviewed the video.
Okay, so in that case, the kids did not have on hats. One girl had on fingerless gloves. The other girl appeared not to have any gloves on at all, and it was 15 degrees. So how would we evaluate the risk there, being that it was so cold out?
But Ms. Ball, the officer himself said he couldn't recall. He didn't see it. And if you actually look, Officer Hatcher is the one who testified. He didn't spend hardly any time with the children. He went inside and was actually dealing with Ms. Ball. So Ms. Ball testified she had just sent out the kids to play before making this trip to Target, and that they were appropriately dressed in sweatsuits, winter coats, boots. She said hats and gloves. Now the winter coats did have hoods on them, I recall seeing. And the one girl, yes, you can definitely see her with fingerless glove. I'm not sure with the younger child, whether or not you can really get a good look at her hands to see whether or not she had gloves, but that doesn't mean that they weren't gloves in her coat pocket, because Ms. Spivey Ms. Ball testified that she did provide gloves to the children, and that they were adequately dressed for the temperature because they had just been set out to play. So in that respect, because she took the precautions and that the children were appropriately dressed for the weather, it's not really that much farther removed from Martin, because again, Miss Ball appreciated the risk of that it was cold outside and appropriately dressed the children. And she had also intended only to be her intention was to be in the store and out of the store, and she in a quick trip, and she was actually trying to do that in under 10 minutes so when she got out there, so she the video will show when she was in the electronics department, when by the time she checked out, only like 8 minutes had transpired. So
Peters, let me ask you a question. Is this case any different from a case, just assume that it was 85 degrees out and your client went in and did what she did. When we look at the recklessness aspect, is it more reckless to leave somebody in a car when it's hot out, or is it less reckless to leave them in a car when it's cold out? Do you understand my question? Is it any less reckless?
Actually, I would say potentially yes, Your Honor. It is less reckless to leave them in the cold versus the hot, because the car will amplify the heat. So even though the temperature outside may only be 80 some degrees, the car itself will amplify the heat. So yes, but I don't believe the reverse is true for cold. So I would say that it would be more reckless. So if leaving a child in a locked vehicle for the same period of time, depending on if it was the heat versus the cold, I would say the heat would actually create more of a risk than cold weather would.
Isn't there another risk here? And that being that there wasn't even a window in one of the places, there was just a plastic tarp. Isn't there a risk that any bypasser could come along, rip that off and grab the children or leave them more exposed to the cold? Or, I mean, aren't there other risks just besides getting frostbite or cold?
Thank you, Your Honor. There was testimony that there was plastic over the window. However, it was made clear to the court that this was not a busted window, that there wasn't an absence of window, that this was like a crack, that the window wouldn't go all the way back up and it wouldn't go down anymore either. So there was like a 2-inch gap. So I don't believe that there wasn't any, so the plastic was covering that to protect from the elements. So no, I don't believe there was any risk of a stranger coming in and accessing the car, like you have seen in other child endangerment cases. The children were secure in their car seat. They were dressed warm, and Miss Ball had, attempted to get back to them in under 10 minutes. In those circumstances, parents will send their kids out to play in this type of temperature for longer than 10 minutes. So just because they were sitting in a car shouldn't mean that she created any more of a substantial risk to these children than if she had been at home and sent them out to play.
Well, I don't mean to belabor this point, but isn't the difference that if she's in home and sent them outside, she can get to them? Here, she chose to commit an act that caused her to be detained, unable to get to the children. And isn't that a significant difference?
But as soon as she was unable to get to the children, she made sure that somebody was able to get to the children. So the children weren't left to be exposed to the freezing weather any longer, really any more substantial time. Typically, a lot of these cases you see it's like the half-hour threshold is when a lot of courts are with some other factors will seize upon. Like in the Lewis case, it was freezing temperatures. It was a 2-year-old, and the child was visibly crying and had debris like food stuff that was a potential choking hazard. So it wasn't just the freezing it wasn't just the freezing temperature in Lewis. It was it was the younger age, that there was a 2-year-old child and the choke hazard. So in this case, what you really have is, yes, they're left in a parking lot, but there's no evidence that this parking lot was in a high crime area or, and it was in the middle of the day, unlike other cases where it's done like at 9 p.m. or, late at night. So the Miss Ball.
You are at your time if you
Okay. All right, then I will just request that the conviction for child endangerment be reversed. Thank you.
Counsel, you have 15 minutes.
Thank you, Your Honor. Good morning, Your Honor. Ms. Peters, may it please the court. I don't have a whole lot to add to what I had in my brief. Judge Myers, I think that your question regarding the difference about leaving your children outside to play versus leaving them in a car with a window open of, 2 or 3 inches and freezing weather, I think there's a big difference, and that shows that you're ignoring a risk. Anything could have happened. I know I think that counsel says that she was in there maybe for 7 or 8 minutes. We're not sure exactly how long she was in there. The store manager estimated she had been in for at least 10 to 15 minutes before he stopped her, because she went to the back of the store, and he only started watching her once she tripped the activation over the headphones. So we're not sure. We're basing the 8 minutes on her testimony, which was less than credible. When you read her testimony, she kind of starts off not so credible because she isn't really straightforward about what her name is. There was some question when she showed the officer her license. There was a Nicole Whitaker showed up. She pretended she didn't know who Nicole Whitaker was. And then finally at trial, she said, "Oh, that's me." And so she didn't start off as the most credible witness. And I think also that goes to whether or not the children were dressed well enough to avoid any substantial risk. Judge Bach, like you said, on the video, you can't see any hats with the kids. The kids had hoods on. I don't believe that they're up around their heads. One child had on fingerless gloves. I believe Officer Hatcher testified that there was frost on the windows when he first walked up. I forget if that was he or Mr. Roberts. Officer Hatcher said that he couldn't remain outside for long without gloves or a hat on without his fingers going numb. He believed that it was probably one of the coldest days of the year. I think simply this just comes down to whether or not she was reckless in leaving them outside to go in to commit a theft. She hasn't appealed the theft conviction. She went in to shoplift, and she left the kids out in the car in cold weather. And Judge Myers, like you said, there's a possibility she's lucky that someone was able to go out and get the kids for her, that she was able to communicate that to someone. But had they just put her in a room and maybe made her wait a little bit, the kids could have been out there even longer. And we don't know how long they were out there in the first place. So unless there are any other questions, the state would ask that the court affirm the conviction for child endangerment. Thank you.
Any questions from the panel? Ms. Peters, you have 3 minutes remaining.
Yes, Your Honor. Although the state questions my client's credibility as far as her timeline, you don't need to rely on her statements. You'll see from the video footage from the timestamps, it's an 8-minute transaction. And my client said she headed back in there. Mr. Roberts didn't know her existence in the store until she triggered when she lifted off the headphones, and that's what triggered the first the video to start. So in that whole transaction between going to get the other grocery items, that was 8 minutes. So you don't have to rely on my client's testimony for that. You just look at the video and you'll see the timestamps. And the video will also show that the children were appropriately dressed. So we would say when you take all the consideration that how she did appropriately dress the children, that she did alert anybody, that she tried to get out of the store in under 10 minutes, and that she alerted someone immediately, shows that she did not create a substantial risk to the health and safety of her grandchildren. And with that, we would submit and request that this court reverse. Thank you.
Thank you. Counsel, thank you both very much for your arguments today. We will take this case under submission and give you a timely written opinion. That will conclude the oral arguments this morning for the First District Court of Appeals.
Thank you.
Thank you all and have a nice rest of the day.
You too.